Now we will move, excuse me, we will move on now to the last lecture on defenses. We will finish the rest of the defenses under Malaysian law. So we have covered private defense, prevention of harm, and now we move on to compelled by threats, which is found in section 94 and similar to the defense of duress under English law. But you will see that there are obvious differences. Section 94 provides that nothing is an offense which is done by a person who is compelled to do it by threats, so duress by threats, which at the time of doing it reasonably caused the apprehension that instant death to that person will otherwise be the consequence, right? So you got to show that the accused here was compelled by threats, and the threats caused the apprehension of instant death to that person. So immediately you see how different it is. Under English law, it can be threat of death or serious injury, but here is only threat of instant death, right? And under English law, it can be to the defendant or it can be to anyone else, even to strangers. But here, it is only the threat of instant death to that person only. So it's very, very much limited, the Malaysian law as compared to English law. Okay, so threat of instant death. What does instant death means, right? It doesn't mean that you die instantly. Okay, so if you threaten the person that he will die slowly, then it will not be caught under this. Basically, what it means is that the threat must be imminent, right? Extreme as well as persistent. That's what was held in the case of Tan Seng An. In this case, where the accused was found in possession of a revolver, and he said that he actually was keeping it safe for two other people who told him to hold on to it to keep it safe, right? And he tried to rely on this defense of compelled by threats, but it was held that there was no threat of instant death, right? There was no imminent, extreme, and persistent threat. In the case of Subramaniam, this was a case where the accused was found, this was back in 1956, he was found holding an ammunition belt. And this ammunition belt consists of bullets, right? Live bullets. No weapons though, just the bullets. And but it is still an offense to be carrying with you live bullets. So in this case, he said that he was actually abducted. He was actually captured by a group of terrorists who actually forced him to help them by carrying the bullets. They didn't give him a weapon. They made him carry the bullets. So he escaped and he was running away from these terrorists, but there was always a risk that he will be caught by them, right? They may come back at any moment. So in this case, the court held that threats previously made could have been a continuing menace at the moment the appellant was captured. So the threat was still present at that time. It was a continuing menace at the time that he was captured with the ammunition. Now, it was also provided that they must reasonably cause the apprehension that instant death to that person will otherwise be the consequence. Right? If you don't carry the crime, then you will suffer instant death. Now, in Muhammad Yusuf bin Haji Ahmad, this was a case where the accused was caught with drugs. This was at Padang Besar. Now, Padang Besar is actually right at the north of Malaysia, right? So you can see that at Perlis and Padang Besar. I drove all the way up there before just to see the Malaysian-Thai border before turning back. And good thing they didn't stop me, because why this fellow comes to the border and then he looks for a while and then he turns back. But in any event, in the case of Muhammad Yusuf, this was a case where he was caught with drugs at the Padang Besar train station. And he said that he was actually carrying the drugs on behalf of another person. Another person threatened to kill him if he didn't carry the drugs. And that person was actually around 20 feet away, right? 20 feet away. And the person said that if he didn't carry the drugs, then he would be shot, right? The person would shoot him. But he was 20 feet away, and the court held that, he could have very easily obtained help or approached the authorities or the police, right? 20 feet away, they felt that there was quite a big distance. So there was no real threat of instant death. And this case is saying that There is also no threat of instant death if the accused could have obtained help from the authorities, right? Could have obtained help from the authorities, then there's no threat of instant death. Now, the exceptions to this to this to this compelled by threats is that it is not applicable for murder, just like under English law. It is also not applicable for offences against the state, which is punishable by death, as well as offences relating to terrorism. And there is also right that there are also the proviso to Section 94, where it provides that the person must not have placed himself in a situation by which he became subject to such constraint. So again, this is quite similar to English law. Basically, if you voluntarily associate yourself with criminal organizations, then you will not be allowed to rely on the defense of duress. Similarly, here, if he place himself in the situation, right, then he may not be able to rely on this compelled by threats. Okay, so the person doing the act did not place himself in a situation by which he became subject to such constraint by his own accord, right? That means he voluntarily did so, or he did so, he joined it because of reasonable apprehension of harm to himself short of instant death. So that itself is not enough for compelled by threats, but it is enough to stop him from relying from this compelled by threats, right? Because if he was compelled by threats, then he would be sorry if he was if it was by reasonable apprehension of harm to himself of instant death, then he can rely on Section 94 to say that he placed himself in a situation because of this threat of instant death, and therefore he will be able to rely on this defense. But if it's anything short of it, then he will not be able to rely on this defense. Okay, explanations 1 and 2 it also helps to explain it and also illustrates it actually, even though it's explanations. You see that explanation 1, it provides that a person who, by his own accord, right? So we're not talking about driving his own Honda, right? By his own accord means by his own free will, or by reason of threat of being beaten, where he joined gang robbers knowing their character, then he is not entitled to the benefit of this exception on the ground that he has been compelled by his associates to do anything that is an offense by law. So if he joins it willingly by his own accord, or if he joins it because he doesn't want to be beaten, then he will not be able to rely on this exception, right, compelled by threats. In exception 2, it talks about a person seized by gang robbers. He is forced by threat of instant death, right? In explanation 1, it was a threat short of instant death, but here he is forced by threat of instant death to do a thing which is offense by law. For example, a Smith compelled to take his tools and force the door of the house for the gang robbers to enter and plunder it. Now, in such a situation, he will be entitled to the benefit of this exception. So that's basically compelled by threats, right? Much shorter, much more straightforward, but it is much more limited as compared to the defense of duress. Next will be intoxication, and this is found under sections 85 and 86 of the Penal Code. Now, the key thing about intoxication is that there must be evidence of intoxication. Both Ismail bin Abdul Rahman as well as Kenneth Fukman Lee, right? In Ismail Abdul Rahman, it was held that that there must be actual evidence. Just a mere statement, right? Just by declaring, by saying I was intoxicated is not good enough. You must show that the person was actually really intoxicated. And similarly with the case of Kenneth Fukman Lee also, right? Let's see how it works. There are two scenarios of how intoxication can work under the Penal Code, right? Under Section 85, subsection 2. The first one is found in subsection 2A, where the accused did not know that the act or omission was wrong or did not know what he was doing, and that was because he was intoxicated without his consent. So we're talking about involuntary intoxication. But not just only involuntary intoxication, it must be it was caused without his consent by the malicious or negligent act of another person. So you see, it is very limited, right? If it's voluntary intoxication, then you cannot use as a defense at all under the penal code. However, uh, if if it was involuntary intoxication, it's only applicable if it was done by a malicious or negligent act of another person. So what if it was a mischievous act by another person? Then can it give rise to this defense of intoxication or not? Would you equate mischievous with malicious? Right. Now, Section 86 provides that if this is satisfied, right, that he was intoxicated without his consent by the malicious or negligent act of another person, which caused him not to know that his act or omission was wrong, or to cause him to not know what he was doing, then he will be acquitted. The second scenario is 85(2)(b), right? Again, if he doesn't know that his act or omission was wrong or did not know what he was doing, and the reason was because he was, by reason of intoxication, insane. That means he was so intoxicated that he's considered to be insane, whether it's temporary insanity or otherwise. Now, if this is satisfied according to Section 86(1), then they will treat it as a case of unsound mind. Now, it's interesting that although under the penal code it talks about the exception of unsound mind, but in Section 85(2)(b), it says that by reason of intoxication, insane. It seems to imply that insanity is synonymous with unsoundness of mind. Maybe they can be considered to be so. If you look at the case law, it does seem that it is used interchangeably, right? In Tan Ho Tek, it was a case where the accused drank a whole bottle of Hennessy, right? Whole bottle. He was intoxicated and he killed his brother in a state of delirium. So the question was whether can he be considered to be suffering from an unsound mind or not. So when is a person considered to be suffering from unsoundness of mind? We will see that in the last exception. But before we go there, right, how does this defense work? Section 86(2) says that this defense helps to determine whether the person charged had formed any intention, specific or otherwise. So basically, intoxication under penal code is only used to show is only applicable where the mens rea is intention, right? That means the offense is only basically a specific intent crime. Okay, that means that we have to see whether was he too intoxicated to have formed the intention. So if the crime can be proved by other mens rea, like rash or negligence or knowledge, then intoxication will not be applicable. It's only applicable to see whether has the accused formed any intention or not, right? Whether was he too intoxicated to have formed the intention. Now, this is very clear in Kenneth Folkmanley's case, right? In Kenneth Folkmanley's case, it was a case where he was charged for murder, and then he did say that he was also under automatism because of the medication that he was in, and it was also caused him to be, well, because it was drugs, it caused him to be intoxicated also, and therefore it was a defense for murder. But the court said that no, because he was charged for murder not under 301, 2 or 3, but he was charged under 304, right, where there is knowledge that the act is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death. So therefore, intoxication is not applicable when a person is charged under 304 because the mens rea there is knowledge, the mens rea there is not intention, because intention is only used to show whether there was intention. Intoxication is only used to show whether there was intention or not. Sorry, this is the slides are changing on its own, right? I think there's a timer set somewhere. I made a mistake somewhere when preparing the slides, right? Now Now, this brings to mind a very recent case where a drunk driver who killed another person was charged for murder. So, because the question then is that, right, if he was intoxicated, can it be said that he didn't have intention to cause the death or to cause a bodily injury under Section 300, 1, 2, and 3, right? However, he will probably be charged under 304 that he was so intoxicated that he had the knowledge that the act is so eminently dangerous that it must in all probability cause death. Uh, so some feel that it was a bit unfortunate because there's such an outcry against drunk driving now that because of that he was charged for murder instead of the normally a person would be charged by causing death by a reckless act. But it appears that because of the outcry over drunk driving that he was charged for murder, and some feel that unfortunately he has already been prejudged, and the court will be under a lot of pressure to find that he is guilty. But yeah, we will have to just trust that the court will be fair and just and come to a conclusion that's not based on sentiments of the public but on the law itself. Right? Now, sections for intoxication also under penal code, just like under English law, drugs, you can be intoxicated not just by alcohol but by drugs also, right? So under 86, subsection 3, narcotics are also included when you talk about a person being intoxicated. Now, finally, move on to the defense of an unsound mind under section 84. Right, which provides that nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to the law. Right, he's doing what is either wrong or contrary to the law. So if you break it up, we see that basically there are two key things there, right? It was by reason of unsoundness of mind that he is incapable of knowing the nature of the act or that what he was doing was wrong or contrary to the law. Now, cases have been very clear that this legal insanity, right? Again, they use the word insanity, right? So seeming to imply that, the court seems to treat unsoundness of mind to be very similar to insanity under English law. And just like under English law, there's a distinction between legal insanity and medical insanity, right? So you've seen under English law that for insanity, it's basically something that is a disease of the mind, which is an internal cause, which even sleepwalking may fall into that category. Whereas medical insanity, obviously, you can't say that medically a person is insane because he sleepwalks, right? So similarly, under Malaysian law, this Court of Appeal case which was approved subsequently by a House of by a federal court case of Durin bin Murrah, but this John Numbe, right? It basically says that for legal insanity, it just impairs the cognitive faculties of a person, right? It just impairs the cognitive faculties of a person, and in John's case, the cognitive faculties was not affected, right? It was not affected. That's what the court found. This was a case where he actually cut off the head of the victim and hit the victim, right? Saying that it was basically because of his unsoundness of mind, and he apparently said that somebody named Jimmy made him do it. Okay, so the court found that there was nothing wrong with his cognitive faculties, and therefore his defense was not accepted. Right? The court basically says that we need to prove the two things that is mentioned in Section 84, which is basically he must be suffering from unsoundness of mind, and because of that, by reason of that, he was incapable of knowing the nature of the act, or that what he was doing was either wrong or contrary to the law. And it was held that only the accused can raise this, right? Only the accused can raise this defense. Because insanity can be raised by the prosecution under English law also. And sometimes the defense would not want to raise insanity because insanity will not automatically mean that the defendant would be acquitted. In fact, it may mean that he will be institutionalized, and that could be a fate worse than being in prison or so. So what is these two things, right? The first thing is that it must show that it was by reason of unsoundness of mind. Uh, this is not defined, right? This is not defined in the penal code, and courts have not really elaborated it. Court seems to usually take it like it's similar to insanity. But the Court of Appeal in Arokia Sami said that it is basically a state of mindlessness, right? As having, it also describe it as having delusions or hallucination. So the sound is not the sound. The mind is just not sound, right? It's just not right. And I suppose the difficult part is the second part, though, incapable of knowing the nature of the act, or that what he was doing was either wrong or contrary to the law. Now, the first part is fine. Because of the unsoundness of mind, the person is incapable of knowing the nature of his act, very similar to insanity. The second part here is that, or what he was doing was either wrong or contrary to the law. So it's either wrong or contrary to the law. Now, how should we read it? There are three interpretations, three ways which have been suggested. One is that we take wrong and contrary to the law to be synonymous. So it's either wrong, or another way to say it is it's contrary to the law. So it's synonymous. Wrong means contrary to the law, and this is very similar to the position in under English law, right? When you talk about it is wrong, the act was wrong, is basically contrary to the law. Now there's another view which is the conjunctive view, which says that you must show both that it was wrong as well as it was contrary to the law. Now the wording itself just doesn't support it, right? Because it says either and uses the word or. So it seems to support the last view, the disjunctive view, which was the view adopted by John Yumbe. And in that case, the court actually referred to the Ratanaus, which is a textbook on criminal law. And they said that this is they took a disjunctive view, so that they have to show that either the person doesn't know what he was doing was wrong, or the person doesn't know that what he was doing was contrary to the law. Because the problem then is that there seems to be a distinction between what is wrong and what is contrary to the law. So under English law, wrong means contrary to the law, but under Malaysian law, it is arguable that wrong doesn't necessarily mean contrary to the law. Okay, so in Durin bin Murrah, the Court of Appeal decision was that the defense must be established by producing expert evidence in court, right? It must be established by producing expert evidence in court. So you must get a psychologist or psychiatrist, right? Expert to come in court to show that the person was of unsound mind. So that's Durin bin Murrah, right? Sorry, it's called appeal decision. I think earlier when I talked about it, I said that it was a federal court decision. It's actually also a court of appeal decision, just like John Yumbe. It's a court of appeal decision. Now, what will happen, right? What will happen in the situation if the person is acquitted? Now, this is under the CPC, right? Under the CPC, which is the Criminal Procedure Code, Section 348, it provides that whenever the finding states that the accused person committed the act alleged, the court before which the trial has been held shall, if that act would, but for incapacity found, have constituted an offence, order that the person be kept in safe custody in such a place and manner that the court thinks fit, and shall report the case for the order of the ruler of state in which the trial is held, provided that if the court considers the magistrate's court, the magistrate may in his discretion, if he considers that the offence charged is not of a serious nature, and that the person can safely be released without danger or injury to himself or any other person, caution and discharge him. So this is what happens, right? Talking about here incapacity, basically the person is suffering from unsoundness of mind. So the court may give an order that the person is kept in safe custody, right? In such a place and manner as the court thinks fit. However, if it's a magistrate court, the magistrate may actually allow the person to go free, right? Caution and discharge that person if the offense charge is not serious and the person can safely be released without being a danger uh, to himself or to any other person, right? If not, then he will be put into a mental institution. So just like under the English law. So that basically brings us to the end of the defenses under Malaysian law. And so that brings us to the end of this week's lecture. Here is the Kahoot pin. Please participate in the Kahoot quiz by 11 p.m. on Friday, the 5th of November. Thank you.